Thanks so much for coming. I know we're starting a little later than we like to start, and that's because there's a meeting on tenure over in Batish, and the professors are all interested in this subject. My name is Robert Myers. I'm the director of CASAR. It's wonderful to see so many faces of people I know and some people I don't. Welcome. If you're not on our mailing list, please go to our website, and there is a little place you can click, and we'll make sure to send you events information on our events. We've already had a couple of interesting events that you may have seen. Lisa Hajar, who was at IFI with Vijay Prashad. Lisa's this year's Edward Said Chair. She was there with Vijay, who was last year's Edward Said Chair, and they were talking about intervention at some fairs. We had David Lloyd, who came and visited one of our classes. He's a professor at University of California, Riverside. He was talking about the boycott investment movement. This is a real extraordinary pleasure for me because it's one of the things that we're doing this year, a whole series of events that are related to national security, interrogation, justice, and Guantanamo. I'm going to let Lisa introduce the guest. I simply want to tell you about a couple of things that are coming up this semester, and then I will turn the program over to her. On November the 12th, our next speaker will be coming, who is Jennifer Holt, and she'll be speaking on the phenomenon of connected viewing, creating a revolution in how our media is created, circulated, and consumed, the functionality of this new multi-platform, socially networked digital entertainment experience is heavily dependent on the cloud and its attendant infrastructure such as data centers. We're going to be talking a lot about surveillance, about the surveillance state, etc. On November 18th, David Nevin, who is the attorney, the principal attorney, I should say, as for Khalid Sheikh Mohammed, will be here. So we're continuing this series, which is an extraordinary opportunity, thanks to Lisa, to get the inside story of what's being done in the name of many Americans. Lisa Parks will be here from the University of California, Santa Barbara early in December. We're still working out the date. She's published on a range of topics from secret satellites to drones to whatever. And she's the author of Cultures in Orbit, Satellites, and the Televisual. So we're working a lot with media studies too this year. Something else that we're doing on December the 8th, David Shumway will be here. He's the director of the Humanities Center at Carnegie Mellon. He'll be talking about both his new book on rock stars and his previous book on John Sayles, the American film director. So this is something that we'll... Get it? Speaking of surveillance.
Can the mosquito speak?
That will be on December 8th. And we have a whole array of very interesting events that will continue in the spring, and we'll alert you about them as they occur. Thank you so much for coming this evening, and I'm going to turn it over to Lisa, who will introduce our guest names.
Thank you. Well, it's going to be a pleasure to introduce James Connell, but before, I just want to extend a special greeting to all my students. Nice to see all of you here. And for those of you who've taken at least my War on Terror class, you know quite well my obsession with torture. And this is something that James and I also share. I've been to Guantanamo a few times and watched him in action. So James Connell, James Connell, who's our guest tonight, is an attorney. He started his legal career as a federal public defender and then worked for about a decade as a death penalty lawyer. And it was his death penalty experience that is relevant to his current position representing Ahmad al-Baluchi, because once the President Obama who had originally planned to close Guantanamo, decided not to close Guantanamo, they did add in an element of allowing or requiring that each person facing the death penalty, which includes his client, would have death penalty lawyers. So he's part of the teams of lawyers representing the 5 defendants in the 9/11 hearings. And so, James Connell is quite a fantastic litigator, and oftentimes ends up doing some of the most interesting litigation of the 5 teams, including having been the one to argue unsuccessfully for the applicability of the Convention Against Torture to people who, like his client, were tortured by the CIA. So without further ado, please welcome James Connell.
Thank you very much. I want to especially say thanks to AUB for supporting this kind of series. It's really unique to have such speakers like this to come from all over the world to speak on Guantanamo, people who are in the trenches on these issues. I'm one of those in the trenches people, and sometimes my view is not broad enough. I have sometimes a worm's eye view instead of a bird's eye view, but I can give you at least today the worm's eye view from the trenches. This week in Argentina, 14 men were sentenced to life in prison for their acts of disappearing people and torture and murder in the 1977-1978 civil war in Argentina. And, you know, that's a long time ago for people who thought that they had impunity for torture to be brought to justice after so much time. And it kind of brought to mind, when I read about that, the statement of Martin Luther King Jr. that the moral arc of the university is long, but it bends towards justice. In that vein, I'd like to explore today some of the questions of, is Guantanamo a war crime? Because sometime people like you may wind up prosecuting those who have carried out torture and enforced disappearance, arbitrary detention in Guantanamo and other places. So before I have to do that, I am required to give you a disclaimer. And that disclaimer is that you should know that I don't speak for the Department of Defense or my office, which is called the Office of Chief Defense Counsel, or really anyone else other than my own personal opinions. So you should not take what I say as U.S. government policy. In fact, the U.S. government could not disagree more with what I have to say. So you should know that. You should also know that everyone who's involved as an attorney in the case has a security clearance, but nothing that I say tonight is based on classified information or confirms or denies classified information. So if you do think that I say something that's classified, if you will please raise your hand, then 2 gentlemen will come through that door and take you outside and shoot you, and then we won't have to worry about that problem anymore. So the sort of central, one of the original sins of Guantanamo, the central problem is the classification of information about torture. For those who are sort of torture geeks, the full phrase is torture or other cruel, inhuman, and degrading treatment, which together gets called ill treatment. I don't always like to use the phrase ill treatment because it sounds too mild, right? It sounds like no big deal. But in fact, it's one of the most serious prohibitions in international law, equivalent to the prohibition against genocide. And so, just to take this out of a technical legal framework for a moment, I'd like for everyone, and I apologize for asking you to do this, but just to imagine just for a moment that some terrible crime had been committed against you. It left you alive, but it left you in pain, damaged, and violated. And then I'd like you to imagine that instead of the criminal who did this to you going to prison, you were put in prison. And then third, I'd like you to imagine that you were never allowed to tell anyone, not the police, not international authorities, not the political authorities, not human rights organizations, no one what happened to you. The only person you are allowed to tell is your attorney. But your attorney is not allowed to tell anyone. It becomes a closed loop that only You can only describe the terrible crime that happened to you to a person who is utterly powerless to do anything about it. That is the scenario of the men who were captured, kept in CIA custody for between 3 and 4 years, and then ultimately were transferred to Guantanamo a long time ago, in 2006, and have been in Supermax prison since then. So don't move on yet, but let me just tell you what the Military Commission, which is a body that exists, military, almost like a court, but not quite, that exists at Guantanamo, has defined as classified information. And this didn't come just from the Military Commission, didn't make this up. This was at the insistence of the intelligence agencies in the United States. They defined as classified information any of the details of the abduction of these men, any country that was involved, even what country that they were in, so that it's impossible to go to seek justice from a prosecutor in that country. The people who are involved, so it's impossible to find witnesses or seek accountability for people who committed torture. And then the most chilling to me, the descriptions, duration, frequency, and sequencing of interrogation techniques. Finally, the conditions of confinement, because when a person is tortured, it's not broken up into time at a hotel interrupted by terrible events. It is one complete terrible event composed, and one of the things we know from Abu Ghraib is how much the people who are involved in conditions of confinement were encouraged to continue the torture even when the interrogation was not going on. So all of that is considered classified. I can't tell you anything about it. But I can tell you a little bit about my particular client, whose name is Alwaleed. So this is Ammar. Ammar was born in 1977 in Kuwait. I don't know if anyone's familiar with the citizenship, very restrictive citizenship laws in Kuwait, but that does not make him a Kuwaiti. He is a Pakistani national. But when Iraq invaded Kuwait in 1990, his family lived under the occupation for a period of time, and then fled to Iran in 1991 before the U.S. invasion of Kuwait to dislodge Iraq. He went to school there. He went to high school in Iran, where when he got there, he didn't speak the language. He didn't speak Farsi. He just had to learn the language and go to high school there. And then after he graduated from high school, he moved to Pakistan, where he continued his education in computers. He's a computer programmer, and then in 1998 he moved to Dubai in the UAE to work as a programmer. He was abducted in 2003. I'm not allowed to give you more details than that. And the President Bush has acknowledged that he was cut in one or more secret black sites until 2006. And on September 6th of 2006, President Bush announced that he was bringing Mr. Alwaleed and 13 other men from CIA detention and putting them at Guantanamo. Now, Guantanamo, as sometimes I've reflected, is really just a move from a black site to a dark gray site. Guantanamo is not a significant improvement in many ways because it is essentially the equivalent of a super maximum prison. And a super maximum prison, which involves almost complete isolation of the individuals. But it includes a few other things as well, which is no telephone calls whatsoever. You can't call his attorney, you can't call his family, you can't call anyone. In 2012, when Mr. Abdulaziz's father died, we went to court to try to get him a phone call to his family to discuss the death of his father. And that was denied. He was not allowed to call his family even after the death of his father. It means no family visits of any type. It means that no one can come and visit him. It means that he's not allowed to have any human contact other than his guards and his legal team. It means that he is denied access to the postal service. He can't write, any of you a letter. He can't write a letter to the Miami Herald or to the UN Special Rapporteur on Torture or anyone else. He's completely denied use of the postal service. They do have the use of the ICRC for basically cards that they can send to their family, and there's a system where they're allowed to write to their attorneys. But other than that, no one. And what the super maximum facility means for people who have not been convicted of any crime, and many of the men who are held in that facility have not been even accused of any crime, although that's not the case for Mr. Alwaleed, but for many of the men it is. What it essentially means is they are treated like the most hardcore convicted criminals, even in the United States system, even though none of them have ever been convicted of anything. Now, it so happens that I am the only attorney who's ever met a client at the detention facility where Mr. Abdulaziz is held. That detention facility is so secret that no one even knows where it is. I got an order from the judge that I would be able to see the conditions of confinement at that facility, and went and basically met a series of guards. They put me in a van with blacked out windows and hung garbage bags from the front so that I couldn't see out the front window, and then they drove me around in circles for 45 minutes so that I couldn't say it was a left turn and a right turn and figure out where it was that way, and then took me into a closed facility where I had 12 hours inside the facility. I was allowed to take 2 people with me. I took a psychiatrist with me, and I took a crime scene detective, a person with experience in documenting this crime scenes so that he could direct photography and so that he could create maps of the facility. All of my notes, all of those pictures, all of the diagrams that we prepared and everything else had to be turned over for classification review at the end. They all came back classified, not a single one came back unclassified so that I could share it or take it to the UN or the human rights bodies or anyone else to talk about the conditions of confinement. The ICRC does take photographs, is allowed to occasionally take photographs. I think it's been 3 times over the course of the 8 years. And this is a picture of Amar himself. So where does this fit into Guantanamo as a whole? Guantanamo as a whole has held something like 779 prisoners altogether. This chart shows, but they weren't all at the same time, so this chart shows that from its beginning in 2001, and the first prisoners actually arrived shortly after that, there were maximum at one point of 684 prisoners. That number is now down to something like 149 prisoners. But one of the things that you'll notice about this chart is, despite President Obama's promise to close Guantanamo, the transfers from Guantanamo, the people who have left Guantanamo either to be repatriated to their homes or just sent to third countries, the curve really flattens out by the time you get to the Obama administration. The blue line is the number of people who are imprisoned, the number of men who are imprisoned in Guantanamo. The red line is the number of people who have transferred or, in a couple of cases, have passed away. And the green line represents January of 2009 when President Obama took office. And what you'll see is that almost all of the transfers which took place from Guantanamo actually took place under the Bush administration, which was surprising to me when I learned it and surprising to a lot of people. President Obama, on the other hand, has only transferred a much smaller number of people and a much smaller percentage of the total people who've been held at Guantanamo. So, why don't we go to the next slide? So, this slide came out more complicated than I meant to. So I'm not going to walk you through every legal twist, but the thing I want to say is the problem of Guantanamo is interrelated with, but distinct from the problem of the military commissions. The military commissions have only charged a small number of men with any kind of crime at all. And the prosecutor has said that the maximum number that he thinks that he could ever charge in the military commissions is 20. And it seems unlikely to me that the number will ever go that high. There are currently 7 men who are on trial in the military commissions. Of the approximately 149 who are in Guantanamo altogether. That means that the vast majority of people at Guantanamo have never been charged with any crime, will never be charged with any crime, and the majority of those people have been what is known as cleared for release, which means either President Obama's task force that he set up at the beginning, or an ongoing periodic review board has said that there's no reason that the United States should continue to hold them. And the majority of people at Guantanamo have been cleared for release. And these people who do the clearing release are not bleeding heart liberals. The people who do this clearing for release are a task force of all the different intelligence and law enforcement agencies who get together, and let me tell you, when these people say it's safe to release you, it's safe to release you, because they have a strong bias in favor of believing the worst about everybody. And so, you know, the fact that so many of these men have been cleared for release for years and years really is demoralizing at Guantanamo. I mean, it breaks your heart, these people who think, what can be done for me? I mean, everybody has said that I should be sent home, and still I'm not sent home. That has a disproportionate impact on Yemenis, because many of the large proportion of the men who have been cleared for release are Yemenis, but the administration has said, although maybe rethinking that, but it has said that it will not repatriate people to Yemen, and no other country has been willing to take them. So the military commissions itself, which is the reason that I, in particular, is the part of the case that I am particularly involved in. There are a lot of men and women who have done enormous work on Guantanamo, trying to get the uncharged men free, trying to close Guantanamo, but my particular piece of it is the military commissions. And that is because Mr. Alwaleed has been charged with essentially money laundering, participating in a conspiracy that led to 9/11, and his role in that conspiracy is alleged to have been moving money from one place to another. If you were executed, you'd be the first person, if you were convicted and sentenced to death, you'd be the first person in the United States history to ever be sentenced to death for money laundering. It's simply not a crime that ordinarily you can receive the death penalty for. But truthfully, it has often been said that there are only two rules at Guantanamo. Rule number in the military commissions. Rule number one is that Khalid Sheikh Mohammed must die. And rule number two is there are no other rules. And they will basically change the rules in any way that they have to accomplish the death sentence and ultimately execution that they're seeking to carry out. The military commissions have had a number of different iterations. We're on the third version of the military commissions now, and that's really what this slide is intended, perhaps not artfully, to show. But in 2002, President Bush issued a presidential order creating military commissions, and then that was struck down and did not go well. And then the military, by the Supreme Court, in the case fairly famous Hamdan v. Rumsfeld. In 2006, Congress, the legislative body in the United States, came back and said, all right, we're going to try to fix some of the problems that the Supreme Court identified, and they created the Military Commissions Act of 2006. There were two major convictions under that. One of them, Mr. Hamdan himself, was reversed on appeal, and he has been released, I believe, to Yemen. And Mr. Alwaleed is the only person at Guantanamo who is serving a sentence. Mr. Alwaleed is serving a life sentence right now. His case was reversed on appeal, and then it was reinstated on appeal, and last Wednesday, it was just argued again, his case was argued again on appeal in the appeal court. When President Obama took office on January 22nd of 2009, he issued an executive order. An executive order is not a law in the sense of a law that's passed by Congress and signed by the President. It's just a decision from the President for things under his control to say, for things that are under my control, this is the way that we're going to do them from now on. And one of the things he said was that Guantanamo would be closed within 1 year of that date, and that there would be a task force, the one that I mentioned earlier, that would decide where to send people and what to do. Some people would be referred for prosecution, some people would be repatriated, and there might be some other solution for some other people. For what, political or otherwise, when January 2010 rolls around, Guantanamo is not closed and is never intended to be closed. There's not really any, although President Obama makes the occasional rare speech on the topic, let me tell you that from the perspective of the person in the trenches, there's no move to close Guantanamo. It's not like they're breaking down buildings when we go there to Guantanamo. Instead, they're laying new cable for improved internet access. They're trying to build new prisons. They're they're making sure that the movie theater for the troops has all the latest movies, and the situation does not look to the, to the many times that I've maybe been to Guantanamo 25 times, and it certainly doesn't look like anything is changing, like it's going to shut down. So the case that I'm involved in is a case that was brought on April 4th of 2012, and that's the 9/11 case. There are two other cases that are proceeding in military commissions. One is the attack on the USS Cole, the case against Mr. al-Nashiri, and another one, the other one is a non-death penalty sort of battlefield case involving Hadi al-Iraqi. So, the question that I want to kind of explore tonight, after having laid that background, is I want to explore the question of, well, is Guantanamo a war crime? If someone else ever convenes a military commission, is it going to be trying the people who are involved in the military commission? I won't lie to you, more than one person has suggested that by participating that I could be prosecuted in that military commission, because I'm the loyal opposition, but I'm still part of the system. So I want to lay that out there at the beginning, and some people believe that. So I know you guys are not lawyers, but I'll give you just a very brief introduction to the law of war. And the law of war, the modern law of war, came about in 1948 with the Geneva Conventions, which everybody's heard of. But although everybody's heard of, not many people really know what they say. They know that they have a certain standard of treatment for POWs. They have a certain standard of treatment for wounded people, people who are rescued at sea, etc. But the law of war is really divided into two categories. The Geneva Conventions were set up after World War II, so everybody had a traditional international armed conflict where one country goes to war against another country in mind. The world having just survived such a cataclysmic war, that's what was principally on the architects of the Geneva Convention's mind when they were thinking. But they did leave one piece in the Geneva Conventions, which is called Common Article 3. You might hear on the news, sometimes Common Article 3 gets debated. And what Common Article 3 says is that in a conflict not of an international character, there are certain minimum standards that you have to abide by. You can't murder anyone, you can't torture anyone, and certain other standards that we're going to talk about in just a minute. Now, here was the most devious, horrible, unbelievable thing that the Bush administration did. Well, one of them I can't say is the most. Everybody can pick the one that they want the most, have their own opinion on that. But one of them was, and as an attorney, a person who believes in the rule of law, something that was unbelievably offensive, was that you had two phrases. You had in an international armed conflict, all of the Geneva Conventions apply. And then you have the second phrase in Common Article 2, which is in a conflict not of an international character, then the prohibition against killing, murder, and torture, and those sorts of things apply. And so what the Bush administration decided in a memorandum that issued in 2002 was, well, we're going to war against Al-Qaeda, the United States. The war against Al-Qaeda is not an international armed conflict because Al-Qaeda is not a state, which is true enough. But then they said, but this is not a conflict not of an international character, because it's an international conflict. And so they said, look at us, we don't have to abide by the Geneva Conventions, but we don't even have to abide by Common Article 3, saying you can't torture or murder people. So they created a third category and said, anyone who is affiliated with, or has ever supported, or has ever been associated with in any way with Al-Qaeda falls outside the whole protection of the law of war. That it's not an international armed conflict, so they don't get Geneva Convention protections. It's not a non-international armed conflict, so they don't get Common Article 3 protection, so they get nothing. We can murder them, we can torture them, we can do whatever we want. Now, to my disappointment, this memorandum has never been formally repealed by the Obama administration. Now, the Obama administration has, and eventually the Bush administration did, say that Common Article 3 applies in the U.S. war on terror. But this reasoning is still out there. In 2006, the Bush administration issued a new policy. It was actually on September 5th of 2006, the day before the announcement of the transfer of these Amar and other people to Guantanamo. On that day, they issued a policy saying that Common Article 3 was going to apply, so we no longer can torture and murder people without the protection of the law of war. But the memorandum itself, its reasoning is still out there and has never really been repudiated. So let's talk about Common Article 3 itself, because let me tell you that Common Article 3 is among other things, and there are some other thoughts on it, but at least Common Article 3 applies to anyone who's captured in any kind of conflict. And that's whether it's a civil war, whether it's a conflict between a state and an organization, between two organizations. Common Article 3 is the minimum, it's the low water mark that any state that calls itself civilized can behave by. And so it prohibits a few things. First is it prohibits cruel treatment and torture. Anyone who has done much reading, or really any reading, about what happened both at Guantanamo and what is alleged to have happened, because I can't confirm or deny, at black sites, and there has been some declassified information about that, hardly anyone could say that what happened was not cruel treatment and torture. I'm not going to go into it here because of the restrictions that are placed on me, but it doesn't take a lot of depth of reading on this topic to understand the cruel treatment and torture that Amar and these other men were subjected to. The second thing that it prohibits is outrages upon personal dignity, in particular humiliating and degrading treatment. The history of Guantanamo itself is replete with humiliating and degrading treatment. One of those has recently had a hearing just last month in the district court, the federal court that governs Guantanamo, which is located in Washington, D.C., about the practice of force feeding. Now, what the situation here is that these men, all of them, have absolutely no power in the system. They're utterly at the power of the guards, and they really only have one way that they can push back against unfair treatment, and that one way is hunger strike. They have control over their own bodies, and they can refuse to eat. What the Department of Defense says is that it can strap the people into a chair, strap their arms and their legs down, and feed a tube through their nose against their will, force the tube through their nose, down their throats, and then pour liquid food, liquid nutrition down a funnel through the tube into their stomachs. And they can do this twice a day, indefinitely. One of the things which is in front of one of the issues which is being discussed right now is, in fact, not only do they do this, they videotape it while they do it. And so the federal court has ordered the United States government to release these videotapes. And right now, they're having debates on exactly what they're going to release out of it, and what they're going to redact, and do they have to show people's names and that kind of thing. But it's down to the details of redaction, and so it may be that soon there's going to be a new wave of unbelievably horrible video, not just still photos this time, that come out of the U.S. detention facility. And the third one is the issue that is of most significance in the military commissions, which is that the Common Article 3 prohibits the passing of sentences and the carrying out of executions without previous judgment pronounced by a regularly constituted court, affording all the judicial guarantees which are recognized as indispensable by civilized persons. Now, without going into too much detail about where those sources come from, but those are the judicial guarantees recognized as indispensable are well set out in other international law. And they include things like the right to be present while you're on trial. Whereas one of the things that's going on in Guantanamo is that these men, whenever the government says that anything is classified, and remember that the people who get to decide that things are classified are the same people that are prosecuting them. Whenever they decide that something is classified, then the men are excluded from the courtroom. If we receive evidence from the prosecution in what's the process called discovery, where they turn over their evidence to us so we can look at it, and they decide that it's classified, then these men can't see it, even though it's in many cases about them. In many ways, they are repeatedly over and over excluded from their own trial. There are other guarantees. One of those is, for example, that the defense has to be able to bring witnesses on the same basis that the prosecution can bring them, whatever that basis is. right? Different systems have different ways to produce witnesses. Some people do it on paper, some people have live witnesses testify, but the idea is that it needs to be fair between the two sides. What happens at Guantanamo is the prosecution can bring whatever witnesses it wants, but what the defense has to do is ask the prosecution to bring its witnesses. And you might not be surprised to learn that the prosecution always says no. We can appeal that to the judge, which is an extremely long and difficult procedure. It takes, by the time that the issue goes before the judge, it's frequently, the issue has already passed by and the witness is no longer needed or available or really involved in the case anymore. Lisa, did you? There are a lot of examples like that. Some of them are a little technical, so I'm not going to talk too much about that, but if we'll just go ahead and I'll finish off here. So I just want to close with, and then we'll have I want time for your questions, but I'd rather talk about what you want to hear about than what I prepared. But I do want to let you know just a couple of things. The first is that we keep a Twitter feed, and that Twitter feed live blogs what happens in the military commissions. You can't watch the military commissions on video or listen to them on the radio or watch them on the internet. So there is a Gitmo Watch with an I in it, GITMOWATCH. If any of you are Twitter users, I hope that you'll pick up your phone. And we already got 5 new Twitter followers today. Thank you for that in class. But we're also working on an Arabic version of that, which is Gitmo Watch AR. So if you prefer to receive information about the military commissions in Arabic, we're working on Gitmo Watch. That's just getting off the ground now, but it is a going concern now. The other place that you can go if you're interested in what we're doing is we have a blog which is gitmowatch.com. That puts out some of the major pleadings if you're interested in saying, hey, just what's going on, getting a perspective other than the mainstream news on what's happening. For example, we recently posted the report that we sent to the Committee Against Torture, who will be reviewing U.S. activities. That happens in mid-November, and it's the first time that the Committee Against Torture has reviewed the United States since 2006. So it should be an important. I hope there are some important and tough questions asked about whether the United States is complying with international law. What questions do people have? Yes?
So that was really incredible and eye-opening. A lot of the details and the incredible kind of sophistication of a system that produces something that doesn't even solve any kind of problems. So my question really has to do with 2 things that you mentioned. One is the Geneva Convention laws, and you have the word occupation. And so one of the things about the laws of war is that when they were instated, I guess there was not really a consideration of colonial occupation.
Yes.
So a lot of what really happened in colonial settings was not really kind of in any way part of that kind of law. Does that feature in, or did that got reformed?
No, it does feature in.
Yeah.
And let me tell you why. Because this green circle here represents the application of the full Geneva Conventions. Mm-hmm. Okay, and it is not 100% mutually. The reason why there's this little overlap here is because it's called Common Article 2. But they're called common articles because they're in all 4 of the different Geneva Conventions. So they're common to all 4. And Common Article 2 says that the full Geneva Conventions apply in 2 situations. The first, international armed conflict, and the second, in situations of occupation, whether or not there was hostilities. Now, what they had in mind when they wrote that was the German occupation of Austria, the German occupation of the Sudetenland. It has also been applied by a Latvian court to the Russian occupation of Latvia. And our position is that the full Geneva Conventions apply, and Mr. Abdulaziz's civilians, so Geneva Convention 4, which is about civilians, applies, because the United States is occupying Guantanamo. You know, the history of Guantanamo is that when in the Spanish-American War, when the United States invaded Guantanamo, after they invaded Cuba, they did so through Guantanamo Bay. They held Guantanamo Bay, And then in 1902, when Cuba became independent for the first time, the United States forced them to place in their constitution a statement that the United States could continue to occupy Guantanamo Bay. Later that ripened into a sort of a lease, and obviously it was opposed by the current Cuban government. And so that, in my opinion, is an example of the late 19th century, 20th century sort of very, very blatant colonialism by the United States, when they'd come late to the colonial party and they were trying to get involved themselves. And so in that, to me, is a kind of occupation. But the other observation I want to make about that is that occupation, according to the commentary to the Geneva Conventions, includes situations which essentially happen by consent. I mean, you think about Austria. Austria agreed to the annexation by Germany. Now they did so under threat of force, obviously, but that's not much different from many occupation situations. And in many occupation situations, there was not even any consent or even pretended consent by some elite within the organization. Instead, it was like what happened in Cuba, which is just a takeover. And so I think there is a lot of room. This occupation clause within Common Article 2 has not gotten a lot of use in the world, right? There's not a lot of law about it. It hasn't come up very often. And I think that it would really be interesting for the thinkers about post-colonialism and the thinkers about the law of war to sort of get together and think about how those two things could come together. People a lot smarter than me could probably do a lot of good work in that area.
If I may, just another kind of comment. So just like a really simple question. Why do you think this whole thing collapsed with Obama's kind of intention to close down the Guantanamo? And in a way, actually seems like even it's heading to a worse place than even under the Bush administration.
Right.
Or it's been heading even.
Yes. Well, the thing, the core of the motivation for Guantanamo exists outside the democratic process. The core motivation for Guantanamo is, or at least for this set of men, is to cover up and suppress evidence of torture by the United States. And the parties who are principally interested in that, are not beholden to Democrat, right? They're not running for election. They're not part of the democratic process. And so they exert a pressure on the democratic process that both probably behind the scenes and in a way that influences the elected members of the democratic process, which, what actually happened, and there's an excellent book by Daniel Clegman called Killer Capture, where he kind of goes inside the White House and tries to answer this question of, all right, Obama showed up and said, we are going to end this Guantanamo atrocity. And then what happened from there? And it's a sort of blow-by-blow explanation of the involvement of the White House Chief of Staff, of the other political advisors to the president, and how they ultimately gave up against the opposition of Attorney General Eric Holder from trying to move cases to the United States for prosecution if they thought they could prosecute them. And so it's partially, it's political in the sense of the internal movements of elements of the United States government, and to some extent it's political in the sense of a lot of members of Congress, both Republican and Democrat, have made a lot of political hay by opposing bringing terrorists to the United States. So even though there are other solutions that are available, none of them are easy. I'm not here to pretend that solving the issue of Guantanamo is an easy solution. But with enough political will, it could be resolved. Yes, let me go to the back of the room.
Yeah, could you say, thank you so much for your talk. Could you say a little bit more about, as a lawyer, your experience of working with documents and working with other kinds of paperwork? You mentioned that, classification practices and redaction practices are sort of can be a hindrance to public knowledge, can be a hindrance to cases, etc. But without obviously divulging things you can't, can you say a little bit about what that has been like for you in terms of getting access to material and whether or not there have been complications in that because of classification and redaction practices in particular?
All right, so the question is the process of getting access to the documentation that's important to the case. And let me tell you that a great deal of my time is spent, on a day-to-day basis fighting for access to the documentation of the case. There are, every outrageous redaction practice that you can imagine has been used by the prosecution in the case. When we received the first, so there was a prior prosecution of a person alleged to have been involved in 9/11, Zacharias Moussaoui. That prosecution took place just after 9/11 and went on for 4 years. And when the FBI, the Federal Bureau of Investigation, investigates a case, they produce reports, right, like police reports. They call them 302s. And that team, the Moussaoui team, received 180,000 pages of FBI 302s. And so, this is the universe of, up to that time, which was only 2004, up to that time, here's the documentation that the FBI has produced about their investigation. Well, when we received the same information from the prosecution, instead of 180,000 pages, it was only 10,000 pages, and it had every first name, every phone number, every address, every bank account number, every ATM number, every phone card number, every credit card number redacted out of it. So, in fact, we did a little calculation. We did the calculation of if you were to cut out all the redactions using scissors in that document and you were to tape them together, then it would be exactly 2.01 miles long of redactions, which is exactly the distance from that you have to take on the ferry to Guantanamo when you get from the airport to the courthouse. And so the 20 minutes that you have to take at the ferry across Guantanamo Bay itself was the same. Guantanamo Bay itself was the same length across as the redactions that the prosecution had produced in the FBI documents. And those were unclassified documents. Right, that's different from the classified documents, which are produced often not in their original form whatsoever, not even with redactions, but are what they call summaries, which is that someone retypes it with the information that they think that we need to know, which, as you can imagine, takes out every detail which makes it meaningful. So, there were many paperwork challenges in the case. I wish that I had more of a challenge managing the waves of paperwork. I wish I had more difficulty with my IT system because that would mean that more information was being turned over to us for the prosecution. As it is now, I have never seen a CIA document regarding the case. The prosecution has not produced any document, any original CIA document to us, anything whatsoever about discovery. So we're a long way into this case already, 3 years into it already, but the truth is, it's not only that there's no end in sight to the case, it's that there's no middle in sight to the case. We're still at the very beginning of negotiating access. We're not in the question of, reading the documents in the case and interviewing the witnesses, most of the witnesses yet. Did you have a question?
Yeah, I wanted to actually ask you about Common Article 2 again. Just empirically, I'm curious how far back that article has been retroactively applied to. Has it been applied to colonial situations prior, or occupying situations prior to the German occupations preceding World War II, or has it ever been successfully that other colonial occupations fell under Geneva Convention for that reason?
It's a fascinating question, and I don't know the answer. I wish that I did, and I'm going to go look it up because it's a new avenue of research on that question. However, I will say that the modern Geneva Conventions, the ones that are right now, only came into effect in 1948. So what their retroactive effect would be, I don't know, but certainly the Common Article 3, the minimum standard should have applied in every War of Independence and every colonial conflict should have applied, because there's a state on one side who is a signatory to the Geneva Convention, and they're bound by Common Article 3 in every kind of conflict. And the only thing that doesn't qualify as a conflict is very small-scale violence, basically banditry as opposed to an armed insurrection. But anytime that you have any situation like that, the Common Article 3 applies. Now I will, because you asked, I will mention, would you go back to that law enforcement slide for me? So I didn't mention it because, but I'm glad to put it on the slide. You see this dark gray spot, which is, that's called Additional Protocol 2. And Additional Protocol 2 is highly relevant to the question of the application of the Geneva Conventions in wars of independence or post-colonial violence. Because Additional Protocol 2 is how it imposes additional responsibilities on its signatories when opposing non-state actors who hold territory. So if there's a civil war or there's a war between a state and a group who is not a state but is organized, who has a chain of command, who displays insignia, recognizable at a distance, and who holds territory, then they're governed by Additional Protocol 2, which imports many of the requirements of the regular Geneva Conventions. And it's exactly that situation that they were trying to address in Additional Protocol 2, because the post-World War II world did not see that. I mean, it saw far too many state-to-state conflicts, but it saw far more non-state conflicts. And that's what, so, you know, when I go to look up that question that you've asked, I'm going to start with Additional Protocol 2, because that's what they were trying to address. So you, I think, have your hand up first.
Yeah, so one of the things we've talked about in Dr. Hajar's class is like the pernicious effects of torture on the torturers.
Yes. And
the way that torture has this effect that it spreads out into the nation that perpetrates it, and it affects the psychology of the perpetrators. So what kinds of gitmoizations of American domestic law do we see already? What's been imported back from Guantanamo Bay into the American legal process, or what do you predict happening?
Right. So one very clear, and stark example of that is the case of the United States versus Ahmed Gilani. Ahmed Gilani was the only person ever transferred from Guantanamo for prosecution in the civilian court. And he was prosecuted in New York for involvement in East Africa embassy bombings in the late 1990s. And what he took with him, shockingly, was the classification of torture. You know, the language that is in our protective order here about using those 5 categories of torture as classified and that no one can speak to him traveled with him to New York. And so for the first time, they took this kind of classification regime and applied it in a civilian court. Now, luckily, we haven't seen it leaking out past there, but I imagine that's only a matter of time. The other question that we have also from the Gilani case is, I don't think that all the legal dust on this question has settled yet. I think there's a lot more to be said about it. But the question of bringing of rendition, not necessarily extraordinary rendition, but a rendition to the United States through alternative means. You know what, the Obama administration has not transferred anyone to Guantanamo since taking office. But what he has done is taken the lesson of the Gilani case, where Gilani said that his statements that he had made had been extracted under adverse circumstances. Some of them were suppressed, and that too much time had passed before they brought him to court, a speedy trial type issue. The administration has started using intelligence and military resources to slowly bring people across the ocean to come to stand trial in the United States, where they can be shaken down for intelligence information on the course of that. And when they get to the United States, then the ordinary law enforcement rules kick in. The rule in federal court, for example, which is very clearly established, been around for more than 50 years, is that after you arrest someone, you have to turn them over to a judicial officer, someone who could say, keep them, or let them go, or there's probable cause against them within 6 hours. And so a second thing that we've seen is this hybrid military intelligence and law enforcement model that the Obama administration is adopting. The last thing that I want to say is one of the saddest outcomes of it is the advocacy for torture as a policy. You know, in speaking to torture survivors outside of Guantanamo, one of the things that I've learned is the feeling of isolation that comes from the fact that not only are you in a room, and not only are you in a room with an interrogator who's abusing you, but past that, there's a wall, and past that, there's another set of guards, and past that, there's there's barbed wire. And past that, there's politicians who are protecting all the people inside the prison. And past that, there's news organizations that are writing in support of the politicians who are protecting the people who are inside the torture center. And the walls of, the layers that press down upon the torture victim, not just the interrogator who sees the suffering that he or she is inflicted, but the people who get farther and farther out from the torture, who are just as corrupted by it, but are insulated from the effects of what they've done. They don't see the person bleed. They don't see the person cry. They don't see the person suffer. And so to them, it's just academic. And so the things that we've seen in the United States of respected political figures arguing for, and a large percentage of the United States population arguing for terrorism, arguing for torture, is really one of the most wide-ranging effects of the ghettoization of America. Yes, Robert.
Thanks. It's fascinating. I wonder if you could talk, since you work on death penalty cases. I'm particularly interested in sort of two related questions. One is this a difference in degree or a difference in kind in terms of a system, a legal system, the death penalty system, and especially, at least, on its face, it looks like the rules of evidence are impossible. I don't really see how you can possibly untangle it, which is why it seems like it'll go on forever. And then the second part of the question is, if it is a difference in kind, you alluded to the conflict you have about actually even participating in the system. Is the participation of lawyers in a system that's extra legal or whatever, is it analogous to force feeding? In other words, if all lawyers say this isn't a legal system, and therefore lawyers are not required here, and therefore there's nothing a lawyer can do. So the two questions are
absolutely. And so the answer to the first question is, having done maybe 15 death penalty cases, something like that, I definitely feel this is different in kind. That this is not simply, and I've done relatively simple death penalty cases. I've done, on the other hand, I was in one of the attorneys for John Al Muhammad, the DC sniper, which was a very large case involving many thousands and thousands of law enforcement, a period of terrorism, intended to strike terror over several weeks period in the Washington, D.C. area, massive amounts of documentation, many witnesses, multiple trials that took place. So I've done every kind of death penalty case, from the very small to the very large, and this is not even on the same spectrum. And not simply in its size, but in the obstacles that are placed in our way. Typically in a death penalty case, the worst thing you need to worry about is the local cops following you around while you go to the county to interview the witnesses. Just a slight intimidation, which you can easily ignore. The impact of the classification laws, the fact that to even see, the client can't call me, the fact that to even go see the client, I have to get on a military plane and a military charter flight and fly down to Guantanamo. The fact that everything in the case, nothing in the case happened, virtually nothing in the case, other than the crime itself, happened in the United States. I traveled to many countries investigating the case. That they're just vast scale and obstacles make it, in my sense, a different kind. The second question is a valuable one too, and it's an equally valuable question, even if it wasn't a difference in kind. It's an equally valuable question. I have many colleagues who say, often after a period of years, but say, I don't want to be part of the death penalty system at all, even as a defense attorney, and so I'm opting out of it. And in my opinion, really there are two legitimate responses to injustice. One of those legitimate responses is boycott. I'm not going to have anything to do with this. But the second legitimate response is engagement, which is that I'm going to fight against it through whatever means that I have available to me. And I respect the people who choose boycott as an answer, and I choose engagement. Yes?
But for example, how can you define the client if you're not, you or the client allowed to prove that, or say the evidence that proves him non-guilty, for example, about the torture? It's not allowed to tell anyway, or you're not allowed to tell anyone else that he was suffering from torture. So where are the evidence? How can we?
So the one thing is that the whole thing is I struggle every day with the complexity of it. So part of the complexity is that I am permitted to say that under the rules that the intelligence agencies have set up, or whoever's in charge of the original classifying authority is the regular, whoever these people are. That under these rules that they've set up, I'm allowed to say that Ammar Alwaleed was tortured. But I'm not allowed to give any details of those 5 categories of things that I put on the board. So I'm not allowed to prove it to anybody. I'm not allowed to tell a therapist, what he's been through so they can craft a method of rehabilitation for him. I'm not allowed to give the details to a court or to a human rights organization that would be convincing to them about what happened. So, but on the other hand, there are things that I can do, and those are the things that I try to do. I talked about the Commission Against Torture review that's coming up. One of the things that I've done is present a report to that commission to say, look at the restrictions they're placing on us. Because one of the rights under the Convention Against Torture is the right to complain, which doesn't mean the right to whine, it means the right to say, look, things have been done to me, right? And to file a complaint. In prohibiting us from doing that, as you say, they violate the right to complain. So it's like an entry point into the discussion about torture. And I will tell you that honestly, I eventually hope that the system will come around on this point. The President of the United States has said that the torture system is illegal and is not allowed to be used anymore. So I don't see why the President of the United States doesn't declassify it. What do we need it for anymore? Right? What is the point of hanging on to these techniques and keeping them secret if we're never going to use them again? And so I do have some hope that eventually the President, and it's entirely within his power, will say, listen, I'm declassifying this program because there's no reason to keep it secret any longer. We should never forget what we did. And so how are we doing on time? I'm not trying to cut anybody off, but we're good? Okay.
Yeah, since there is no law applying Guantanamo prison, so theoretically just speaking, can it be the case that they can test like kind of mental weapons on the prisoners?
So,
or kind of education, scientifically, like it was during World War II?
Yes, so one of the things that Common Article 3 prohibits is the medical experimentation. And whether they did medical experimentation on these men, I have no idea. There have been news reports of that kind of thing. I don't know whether they're true or not. I'm not confirming or denying them. But under the Bush memo interpretation, they would have every right they would have the authority to conduct medical experimentation on them. I don't know if that happened or not, but certainly the Bush administration claimed the right to do it.
And one more question.
Sure.
Yeah, the people who are working there, the workers, the army, I don't know what they, how are their mental situation? Like, are they mentally retarded? How they can do this and torture people? And are they harmed by themselves? Like, I don't know. I can't understand how they can actually do this.
I think many of them are harmed by their time there. One of the points that you made was that the people who are involved in abusing others are themselves a form of victim. And that really happens in this situation, where some of the men and women who've been there have talked to me afterward and have said, listen, it was terrible. It was terrible what I had to do there. It was terrible what happened, what the situation that these men were in. But you have to remember that they rotate them very frequently, so they're always a new crop coming in, and so many of the people who go there are your age, are student age, right? Because they're young people in the Army or the Navy or the Coast Guard or whatever. And so many people who don't themselves remember 9/11, so they do things like, play emergency phone calls to them from people who are dying on planes. They spend a lot of time telling them how terrible and dangerous these men are. And so when they get there and they see the men are not terrible and dangerous, and really they're just going about their lives in the tiny confines as best they can, they think it must be a trap, right? It must be a trick, that they're trying to lull them into a sense of security so that they can do something. I've heard that called stress through work underload, which is that it's how terrible it is to be a guard in one of these situations because you spend all day waiting for some sort of explosion, right? Something terrible is going to happen. and nothing terrible happens. And then the next day, you spend it all waiting for something terrible happens. And so eventually, when some minor thing does happen, you totally overreact to it. And you know, one of the things that's been discussed in the hearing in DC last year is these forced cell extractions, the tackle and shackle, where they go in and, you know, 8 or 10 people, I don't know how many, a whole bunch of people go in and jump the person, abuse them and tie them up. So that cannot, unless a person is truly sick and sadistic, that cannot not have an effect on the guard to have participated. And I think over the years we're going to have, as some people already have, people coming forward to say, I can't believe the terrible things they made me do, I can't believe the lies they told me. So yes.
Now, where does the court challenge from 2 weeks ago about the lubrication of feeding tube to the Alwaleed currently stand?
So the judge hasn't ruled on it yet. Okay. The judge has issued some rulings about the release of the videotapes, and it's essentially a redaction process where you can kind of understand that there could be legitimate security concerns, and the fact that they are going to reduce the most of the videotapes doesn't necessarily mean they have to produce every single second of it. So they're in a process to see what kind of form that they can release the videotapes in. The judge has ruled on that, and but the judge has not ruled on the force feeding, the lubrication issues, the forced cell extraction issues.
Are they currently still using olive oil, or have they switched to a water soluble?
That's a good question. I don't know the answer.
They switched.
Is that right? Okay. I mean, I know that the olive oil was not, or what I had read about it, I don't know personally, but what I had read about it was that it was not in every situation. It was something that they did sometimes, and I didn't know what the...
No, it actually, doctors testify that it can cause pneumonia, yeah. So for that reason, they just changed their standard operating procedure.
Did you say, so...
In other words, you put olive oil to lubricate the tube when it goes through their nose.
Yeah.
The doctor said that's a terribly stupid thing to do from a medical point of view. So they've now stopped using olive oil and they use the water-soluble stuff to get the tubes down.
So they use medical gels to do that?
They thought that these guys were Arabs. Olive oil, they like their olive oil. I mean, seriously. During Ramadan, they force feed them Ensure flavored, date flavored Ensure, because they know Muslims love dates on Ramadan. So.
And they do it at night.
Pardon me?
And they do it at night.
Yeah.
You know, but since we're talking about medical ethics, the thing that you can't forget is that the World Medical Association has very strongly come out and said that people have the right to control their own bodies. And if they don't want to take in food, they don't have to take in food. And you can't force feed anyone. You know, it's been strongly suggested, and something that is going to be discussed at the Committee Against Torture next month, is that force feeding itself is a form of torture, which having a tube rammed down my nose would certainly be a form of torture. So I can't imagine the horror that those guys go through. Okay.
Yeah. Does anything exist that guarantees that Guantanamo won't be repopulated should the current administration or the next one decide to take on a more shady information extraction technique?
Absolutely not. There's nothing that says that we can't repopulate Guantanamo. And in fact, each time a terrorist suspect is arrested overseas, there's some voice in Congress that pops up and says that the United States should not bring the person to New York or Virginia or DC or wherever, but should instead take them to Guantanamo. And so far, this administration has resisted those calls. But there's nothing to say that the next administration won't say, hey, we have all these empty cells, why are we letting them go to waste? Yes?
Thank you for this talk and sharing your experiences and insight. And there's something about this phantasmatic construction of authority that hangs over all this that kind of horrifies and fascinates me. And so I have sort of questions about two things. One, I like how you stress the fundamental continuity between the Bush and Obama administrations as far as these sorts of practices go. And Obama made the promise to close Guantanamo, which then sort of didn't follow through. So the first question is the closure of Guantanamo, is it a symbolic act of closing a heinous place, which would leave the rest of black sites intact, like you close the dark gray site, but the black sites then stay open? There's which, the sites that we know exist but don't know about, and so on. The second question is about standards of evidence, right? There's certain kinds of evidence which the powers that be have determined cannot be released at all, then another category of evidence which can be released but heavily redacted, 2.01 miles, released in 1 trove of documents. But presumably you can still talk to your client. So my question is, are there restrictions about what you can talk to your client about and how you document that, even that encounter?
Yes. All right. So let me start with the second question, and I'll go back to the first one. So the second one is the history of my particular involvement in the military commissions is a history of trying to talk to my client. When I first showed up in October of 2011, my first trip to Guantanamo for this round, I was mildly involved in a small role on the first of all military commissions. Essentially, the day that I got there, the military carried out something which has become known as the baseline review, which is they went into the people's cells and they seized all of their legal materials, years and years of legal materials, correspondence with their attorneys, the notes on how they wanted to conduct their case, seized all of their legal materials and went through it and read it, cataloged it, put stickers on it, and all kinds of things. So perhaps not surprisingly, Mr. Alwaleed said, well, I'm not talking to you, right? I don't even have any legal notes, and plus, what could you couldn't stop them. You don't have any power in this system, right? You're a chump in this system. And so I kept coming back, and what happened after that was that officially the military claimed the right to read our legal mail. And attorney-client confidentiality is a big deal in the American legal system, their legal system. And they claimed the right to read our mail. So my boss, the Chief Defense Counsel, said, I'm going to order a boycott. We were talking about boycotting engagement. He said, I'm going to order a boycott. No one can send any privileged material to Guantanamo because they're going to read it. It would be unethical for you to do so. So at this point, I can't even write to Amar, right? I can't even give him, talk to him. I can't even write to him. I can't call him, obviously. And he's not coming out to see me. Because I don't have any more power than a guard, right? I have less power than a guard. They can take his stuff and I can't do anything. Without belaboring the point, everything past that has been an order or something that limits the information that we can send them unless we make certain promises. Other information we can't send them. We've had days and days of hearings of what attorneys did send, over the inability to get client visits, all over the lack of telephone access, but I just will tell you this quick story, which is the day that it changed, which is that I mentioned earlier that I was allowed to go. The judge ordered that I could go to the camp to see the conditions of confinement, to see Amar, and after we had spent 8 hours documenting the situation, then we had 4 hours left because it was an order for 12 hours, and so we were allowed to go into our cell during that time. And we hadn't had anything to eat because it had been 8 hours and we couldn't really take anything in with us. And basically everybody on the block heard about this situation, maybe from the guards or I don't know what, and they all took their evening meals and passed it down to us. And the guards carried it down to us, and in the most secret picnic of all time, Amar was our host, and we were his guests. And so he explained to us, this food is terrible, don't eat that. This is actually kind of okay, and this is not that bad if you put lemon on it, and fed us. And it was at that time that he said, I'm going to give you a chance, Jay. I'm going to say, there's things that we're going to always disagree on, and there's things that we agree on, and there's things that we're just going to have to, argue about until we reach a compromise. And that's the way that we've been working together on the case ever since. So I'm just worried about your time, so I'm not going to
could you say something, maybe a little bit more about because one of the phenomena of Guantanamo, the whole war on terror, was American lawyers representing, people of various kinds, including and particularly the ones who are in these two cases, not having any experience dealing with people who've been tortured.
Right.
So could you talk a little bit more about what you can say of, if what's not classified about dealing with Amar who has been tortured, and how it's affected you?
Sure. So the first thing that Amar had to teach me was how to talk with a person who's been tortured. And it's delicate. I mean, it's a delicate question. You know, one of the things about post-traumatic stress is that it has a lot of triggers. And, you know, there are many ordinary things that played a role in his torture that if I did, they would just trigger. And the, you know, one of the very first things that we talked about was the need for rehabilitation. You know, there are a lot of great people doing a lot of great work in asylum and other situations where people are trying to provide rehabilitation services for torture victims. And one of our main goals in the case is to someday, eventually, get torture rehabilitation services for Ammar. Because it's difficult, right? You know, if I fill out an application for him, he can't show up for the interview. No one can, from a torture rehabilitation center, can come and visit him because they don't have the security clearance. And so there are many, many difficulties with this, but it's something that we have struggled with. Now, you know, you're just seeing me, but in fact, I'm one of a team of people. And let me tell you that many of these people on the team, they didn't sign up for this, right? Some of them are military who were assigned here who didn't want the position. Some of the military who did want the position. Some are civilians who didn't know about how to deal with torture victims, because who knows how to deal with a torture victim, right? It's not something that any of us learn about in any kind of school unless you're a psychologist, person who's focused on it. And let me tell you, it has a lot of impact on people. You know, when people come back from Guantanamo, I can tell how much that toxic place affects them. And it has a lot of impact. We spend a lot of time, our team, worried and working on the effects of secondary trauma. You know, it's a big issue. It's something that we have had to learn, but we're still learning. You know, it's just a struggle that we go through. Was there a question somebody? No? Okay, sorry. Yes, go.
Is it similar to the examination time that we used to have in the laboratory? Because it's also people when they are released, they need many years to adapt to the normal life, outside life. And it's a bit similar because the guards are torturing them, and this is what used to happen. But it's almost the same story that's happening again, maybe in a modern way.
That's right. And one important way in which it's worse is that a person who is released from one of these horrible situations at least has some resources that they can draw on, right? They can draw on their family as a resource. They can draw on their clergy as a resource. They can draw on people, professionals and experts. You know, they can tell their story and they can tell their truth of what happened to them, which in many ways, you know, they call it recapitulating the trauma, right? They can talk about it and get a sense, make sense of it, or at least come to the understanding that it is nonsensical and cannot be understood. Whereas men who are imprisoned in Guantanamo have none of those resources, right? They don't have a paintbrush that they can paint with. They don't have they can't use art to express themselves. They can't use their families to fall back on. They don't have any of those resources that people who have been released from these horrible situations, even those resources, take years and years and years to process what happened. Yes?
Why you're working with Ammar, not with other people, like he's your client?
Yes.
Why him? There are other people also, like his family, like explaining to you you're his advocate or nothing like this from the government. Why Ammar?
So I was assigned to Ammar. I'm paid by the U.S. government, and well, it's a little bit longer story than that. What originally happened was, I mentioned that there were. Can you go to the slide of the military commissions?
You mean this way? The other way?
Keep going, the other way.
Yeah.
So there were really two different military commissions. One under the Military Commissions Act of 2006 and one under the Military Commissions Act of 2009. under the first time, there were only military lawyers who were involved, and then some human rights organizations put together some money to fund civilians to be able to go to Guantanamo and help. I was one of those civilians. I wasn't the main lawyer or anything like that, but I was one of those civilians, and I was working on behalf of Amar. I never met Amar at that time. I didn't have a security clearance at that time.
But they're working on behalf of other people, right?
There are other people who are working on behalf of other people.
Oh, okay.
And so the when they brought back the charges in the second military commission, and they reached out to me to say, would you be willing to come back and work on the case? It was only natural that I would go to work on Amar's case because I had already been involved in his case, already knew a little bit about his case. Yes.
You mentioned that he was arrested because of money laundering.
The allegations against him in the military commissions are essentially moving money from one place to another. Money
Who
laundering.
were financing him? Or why did
So the allegation so the allegation in the charge sheet is that his uncle, who is Khalid Sheikh Mohammed, gave him cash and said, essentially, people are going to call you and ask you for this. And two of the 9/11 hijackers did call him, say, please send me the money, and he wired the money. That's the allegations in the charge sheet. Yes?
I'm just curious about one thing, like to what extent the lawyers that are assigned to the victim, to the detainees, can help these detainees get away, like get out of Guantanamo, or like help them in their case. Like to what extent can it work? Can, like, how can, does people who have lawyer get out actually from Guantanamo, or they stay, or how difficult is it in reality?
Well, it's actually very difficult for any of the people who are working on, especially the uncharged cases, to negotiate some kind of situation. It's a political act each time the president or the Department of Defense authorizes the release of a prisoner from Guantanamo. It has political consequences for them, and there are sort of some difficulties baked into the law where the Secretary of Defense has to make certain findings, etc. So it's incredibly difficult, and each new person who's transferred out of Guantanamo is the result of many, many hundreds and usually thousands of hours of work, hard work by people who may never be recognized for it. So listen, I want to say we're going to pause there, and I want to say thank you guys for very much. A couple of things. Please consider following us on Gitmo Watch because it is important. One other thing, people ask, what can I do? If there's anything that I can do, there's one idea that Dr. Ajar and I came up with the other day, which is that the information about Guantanamo is so bad. I mean, the quality is so poor. So many people turn on Wikipedia.
Wikipedia, sorry. WikiLeaks is awesome.
I can either confirm or deny. But it is important, and there's a lot of useful. There's so much information in the world that never gets condensed down into resources like Wikipedia. So if any of you are interested in Wikipedia or Wikipedia editors, please keep up with the news, and if you improve 3 sentences on the Wikipedia for the military commissions or something like that, it makes a big difference because the next 100,000 people who come along to see what's going on in these Guantanamo military commissions, what's going on, is Guantanamo even still open? Then they'll profit from your work. So it's just a small portable solution that I want to offer to you. Thank you very much. Thank you for your questions. Thank you for your questions.